Hello, everyone, and welcome to Uncivil Law. And for today's case, we have a Title IX discrimination case. A man was accused of misconduct by a college and was expelled, but he was not given due process along the way. The court is not happy about it. And so this tale is going to be recounted, and the courts are going to once again remind universities that they are actually obligated to give due process. And perhaps somewhat of a note of relief, the Department of Education recently came out with formal rulemaking that makes a lot of this official. So hopefully that will actually become a new reality as colleges try to go implement that. I'm sure a lot of them will resist, but this is a thing. And the courts keep doing this because the universities keep violating people's rights. So we're going to cover this case. This is John Doe versus Oberlin College. So let's get started with this. Oberlin overhauled its policies in 2013 and 2014 in response to a very public complaint by a female student. That student had two complaints in particular. The college had taken too long to resolve the claim, thereby harming emotionally, and the student had received too light a punishment. He was suspended rather than expelled. The college formally revised its misconduct policy in May 2015. Relatedly, Oberlin instructed its faculty via its online resource guide that they should believe students who report assault because a very small minority of reported sexual assaults proved to be false reports. So yes, hashtag believe all women was actually official policy at Oberlin. And no, that actually violates due process. You can't do that. The policy, which was adopted in 2015, defines sexual assault as having or attempting to have sexual relations with another without consent, which is a reasonable definition. Intoxication precludes consent only when it results in incapacitation, which the policy defines as a condition when a person lacks conscious knowledge of the nature of the act or is physically helpless, which incidentally is also a crime. If a person is incapacitated to that degree, that's the crime. That's a crime. Examples include when a person is asleep, unconscious, or otherwise unaware that activity is occurring. That's a crime. So if that's happening, the police should be looking into that. A website maintained by Oberlin's Office of Equity, Diversity, and Inclusion reiterates that incapacitation describes a level of intoxication in which a person is unable to control their body or no longer understands who they're with or what they're doing, which is a crime. Charges of assault based on incapacitation require an assessment of whether a responding party or a sober, reasonable person in that position knew or should have known the person was incapacitated. So it may require knowledge on your part. That's perfectly fair as mens rea goes. So having discussed the background of how this wonderful policy came into place, we have to discuss how it applied to John Doe. If John Doe was given the process that it was required, answer no. But let's discuss more. The incident at issue here occurred during the pendency of the office's investigation in the early morning of February the 20th, 2016. The complainant referred to this in litigation as Jane Roe, and the accused referred to as John Doe. I do like it when courts remember to use the female version for, I do like it, Jane Roe. Yeah. We're both undergrads at Oberlin. Doe was then a junior. The complainant does not specify what year Roe was. The two students had met at a party in December 2015, after which they spent a night in the man's room and had consensual relations without protection. For the next 2 months, they had little interaction. On February 27, 2016, Roe went to a concert and then at least to one party afterward, which she consumed alcohol. At 1:02 in the morning on February the 28th, Doe texted to Roe, "What are you up to tonight?" The two then engaged in 9 texts during the next 30 minutes. Roe texted she was about to smoke a little bit of dope in the residence hall where Doe had a room and asked him, "Cool, mind if I come up a bit?" Doe responded, "Yay," and the two arranged to meet in his room. So, okay. So Roe was the one who suggested coming up to his room. All right. Roe arrived at 1:45. The two briefly engaged in small talk before making out and then taking off each other's clothing. Then, at her request, he put on protection and the two had some sort of relationship. They stopped when Rose said she was thirsty, at which point Doe apparently took off his protection, wrapped the towel around himself, and got some water in the hallway. They then resumed having relations, this time without the protection, until Rose said she was dry down there, explaining that she was not sober. Doe stopped the relationship and asked Roe if he perform oral relations. Roe agreed to that. After they engaged in small talk, and Roe left, saying she had a lot to do the next day. 9 days later, Roe went to Ramamond and said that the guy had sexually assaulted her. Ramamond did not inform Doe until the charge until a week later, in which she told him by email that only the college was investigating a report that Doe had sexually assaulted Roe on February the 27th, which she was incapacitated due to alcohol and unable to consent to the activity. Again, if she was incapacitated, then why aren't the police also investigating this? Because that would be very, very illegal. So why are the police involved? That's a reasonable question I'd like to know the answer to. Doe did not learn of the substance of the allegations against him until July the 7th, more than 4 months after the charges were made, when Nolan finally submitted his report. Nolan had interviewed 10 people with knowledge of the events on the 27th and 28th, including Roe and Doe, in addition to interviewing Raymondo. For the most part, on Roe's account of what happened in the room was consistent with Doe's described above, but there were a couple differences, in which Roe stated that before the two had engaged in relationship, Doe had asked for oral relationship, and Roe responded by asking if he had protection. Roe did not mention saying she was thirsty or that Doe had gotten her water. She did say Doe asked for oral relationships after they stopped having more physical relationship, and she said, okay, but I'm not very sober right now. And during the oral relationship, Doe kept pushing her head down and causing her to gag. Separately, the report noted that in a personal journal after, Roe asked Doe that he asked her to go down on him. Most of the other interviewees were friends with Roe. One stated that Roe was intoxicated that night, but not overly so, and the Roe speech was not slurred, and she seemed steady on her feet. Another friend asked Roe said that Roe was out of it and very distant. A third friend who saw Roe immediately before this said that she asked Roe, "You good?" and Roe said yes and walked off to the room. Nolan also interviewed 3 of Roe's friends who talked to her after the incident. One lived in the same residence hall as Doe. Roe visited her shortly after, saying, "I can't believe I was with Doe." And she was disappointed and upset she had done something. So maybe this is more about regret than lack of consent, possibly. That friend said Roe's speech was slower than usual, but not slurred. A second friend told Nolan that on February the 29th, Leap Day, Roe told her that she'd been too intoxicated to consent. Neither of these friends said anything about Roe saying that Doe had used any force. A third friend saying 3 or 4 days after the incident, Roe had asserted that Doe had sexually assaulted her by using force. The college thereafter sent this matter to a panel, why not to a cop, I don't know, which set a hearing date of October the 5th, 2016. So this is now 8 months after the incident. A few days before the date, Doe asked the Title IX team to assign him an advisor during the hearing. Such an advisor, the college conceded during argument, is supposed to serve the best interest of the accused at the hearing. So this advisor was supposed to look out for Doe. That was his role, but not so much now. The Title IX team appointed Assistant Dean Adrian Barusta as Doe's advisor. So they appointed an assistant dean who, again, is supposed to look out for his best interest. That's his job. So good job, Adrian. As an advisor, he left the hearing early. So even though his job is to help protect his interests, he left the hearing early and stopped protecting his interests. And then 2 weeks later, the advisor, whose role, remind you, is to look out for his interests, 2 weeks later, he tweeted, "To survivors everywhere, we believe you." You know, I know he's not an attorney and all, but, this is not really good practice. I think you'd be upset if your attorney 2 weeks after defending you said, "Yeah, we believe survivors," when his obligation is to defend you. So, not so great on the defense team, it seems to me. On October the 6th, 2016, about 240 days after Roe's complaint, the hearing panel issued a decision on which it found Doe responsible for misconduct because the preponderance of the evidence established that effective consent was not maintained for the entire encounter that occurred. Consent was absent, the panel found, because Roe was incapacitated as the policy defined it, from the moment she told Doe that she was not sober. The panel cited no other behavior supporting a finding either that Roe was incapacitated, as defined by the panel, or that Doe would have any reason to think so. Nor did the panel mention the contradictions cited by Nolan between what Roe had told him and what she told the hearing panel as to whether Doe had asked for oral relationship. As a sanction, the panel recommended the most severe one. The college accepted the recommendation and ordered him expelled. So they are not following their own definitions. Their own definitions are pretty clear. To be incapacitated, you have to be unable to consent. You can't know where you are. You can't know what you're doing. You don't know what's going on. And so they didn't follow their own standards and then recommended the most severe sanction. And also his own advisor went out. And also the people they interviewed were her friends. They didn't interview his friends. They interviewed him, but so the whole thing is a due process violation from start to stop. Great job by everyone on Oberlin. Just way to go. Doe appealed 2 weeks later, challenging on 3 grounds the panel's findings. The first one was newly discovered testimony of JB. So there were other people we could have interviewed. JB emailed Raimondo as soon as he heard about the panel's decision, stating Roe had told him that Doe did not use any force on her, and her testimony mischaracterized the nature of their interaction in other ways. Raimondo apparently never responded because, that contradicts the narrative. A second ground of appeal was a statement by HH, a mutual friend of Roe and Doe, who stated that, as Roe was about to leave for the room, she did not appear to be drunk and her speech was normal. The college denied the appeal about a month later, dismissing these statements as largely cumulative, even though they undercut the narrative directly, and Dr. Emerson's letter as largely irrelevant. The college also upheld the sanction almost with no explanation. So having covered this wonderful due process violation, our friend Doe here would like to sue very much because he was denied due process and they didn't even uphold their own standards. So let's review that. Doe thereafter brought this lawsuit, claiming the college was an egregious misapplication of the policy's definition of incapacitation, was the result of discrimination in violation of the law. Doe also brings claims for breaches of contract because of the breaches of policy and negligence under the relevant Ohio law. In our case law, we have held that patterns of decision-making in university cases can be shown a requisite connection to discrimination on the basis of a protected class. We begin with the clear procedural irregularities in the college's response as to these alleged misconduct, which, as the Second Circuit has held, will permit a plausible inference of discrimination. The college's own policy states it usually investigates and will be completed within 20 days, and the whole matter will be resolved within 60. But here, the investigation alone took 120 days. Doe was not even informed of the specific allegations against him for that period, and the hearing panel did not reach a decision until 240 days, which was 180 days later than contemplated by the policy. That delay was compounded by the college's failure to do what the policy twice promised it would do, namely notify the parties of reasons for delay and expected timeframes. Doe's complaint also cites Oberlin's spring 2016 campus climate report, which states that during the very academic year in which Doe's responsibility was determined, every single case that went to a hearing panel resulted in a decision the accused was responsible on at least one charge. Well, 100% conviction rate. 100% conviction rate in Oberlin College, man. Geez, not even Russia or China or North Korea can claim a 100% correct conviction rate. So I don't know what these people are doing in Oberlin, but man, I'm pretty sure that people are found not guilty more often, even in North Korea. This is stellar, man. Excellent. Just genius work. Genius work, Oberlin. Well done. Oberlin responds to this by responding that only 10% of these allegations were resolved through a formal hearing. But Doe reads that same report to mean that 80% of the cases, the complainant himself chose not to pursue the matter. In still other cases, the respondent party has graduated. And in any event, the 100% responsibility rate, in cases where most, if not all, the respondents were male, support an inference regarding bias in the hearings themselves. But Doe's strongest evidence is perhaps the merits of the decision in itself in his case. True, the first element of an erroneous outcome claim, where the facts of the case cast some articulable doubt on the accuracy of the proceedings' outcome, already takes into account the proceedings' outcome to some extent. But when the degree of doubt passes from articulable to grave, the merits of the decision itself, as a matter of common sense, can support the inference of bias. And on the merits here, the panel decision was inexplicable. Per the terms of Oberlin's policy, intoxication does not negate consent. Only incapacitation does. So not intoxication, incapacitation. The policy rather precisely defines that term as well. And the record here provides no apparent basis for finding that Roe lacked a conscious knowledge of the nature of what was going on, or that she was asleep, unconscious, or otherwise aware of what was occurring, or she no longer understood who she was with or what she was doing. Nor there was any reason for Doe to perceive that Roe was in this state. To the contrary, Roe was conscious and aware enough to engage in coherent exchange of text, to make small talk, and to reason that we are no longer wearing clothing, and I feel if anything was to continue, I wanted protection. Thus, on this record, and making all inferences in Doe's favor at this stage of litigation, one could regard this as nearly a test case regarding the college's willingness to ever acquit a respondent. Doe has amply stated a claim for discrimination in violation of law. Thus, this is the end of the case of John Doe versus Oberlin College. In this case, John Doe was accused of a bad thing, and then Oberlin College didn't obey its own standards. They didn't come to the right standard of judgment, they didn't interview the right witnesses, his own advisor ditched him and then threw him under the bus, and basically it all went completely to crap. And John Doe has been discriminated against in violation of law. And this is not the first time we've seen this. We've seen quite a few court decisions along these lines, and colleges seem not to learn. But perhaps with the new guidelines from the Department of Education and Betsy DeVos, the new regulations that are on the books, perhaps now we will finally get some due process. But at least as to John Doe, he gets his relief, and that's the end of the coverage of this case.